Hi, good morning, and welcome to this part 3 of the EU AI Act. I'm your host, Savit Vittal Salian. Let's start the journey. In this part 3, we will be looking at high risk AI systems. This is part of Chapter 3, Article 6. As is the best practice for learning, I start off with case studies that helps us with our base, provides us a perspective so that when we enter the definition and the other technical aspect, the case studies help us to correlate. Case studies which are provided here are one which illustrates high risk AI systems under the EU AI Act. These AI systems fall under Annex 3 and Article 6, where their use is allowed but strictly regulated due to potential impact on fundamental rights, safety, and well being. The first case is a case wherein AI is used in credit scoring system in the banking industry. A large EU based bank deploys an AI powered credit scoring system to assess loan application. The algorithm analyzes behavioral data, financial history, and social indicators to automate lending decisions. From an EU Act perspective, this touches the Annexure 3, Section 5, which states AI used for access to essential services, including credit. It is high risk due to the impact on the economic, livelihood, and privacy. Yes, indeed. It's a loan application from an individual or a group. If the loan is not passed because of a flawed AI system, it impacts that individual, potentially the livelihood, or it could be any other combination, but an individual is directly impacted. The requirement which the Act lays down is the criteria. The AI can be used, but we should know the criteria on basis of which the decision was taken, which means it requires transparency on what formed the rationale to reject or accept a certain application, which means it needs a clear documentation on the way the AI uses the logics to arrive at a conclusion. We need to have a documentation wherein how AI decided against not providing versus those which were provided, so as to ensure there are no biases. When we look at it, we were very clear what were the rationale, and we can analyze if there was anything biased for the same criteria. Again, it is important a very clear documentation is set in place. The next requirement is the AI can perform its analysis, provides its result, but the final decision of allocating or not allocating the resources to the individual or the applicant should be with the human. The last is record keeping and documentation, which I mentioned, which effectively means that AI can be used to do its work analysis, provide criterias, and come to a conclusion, but this needs a vetting by a human, and all the logics and the processes followed by the AI need to have a clear documentation trail which can be reviewed for bias, any biases, which can be reviewed for clarity as to why something was passed, why something is not. The outcome, the AI system must be audited for fairness and explainability. Failure to comply may result in fines or restriction on deployment. Now, here is where risk management need to come into play. A risk manager who is responsible for this system or the business, supporting the business, the risk manager would be required to ensure the process has all of these requirements in place. Risk manager is aware about the steps the AI has taken to come to a conclusion. The risk manager needs to ensure that all due processes are followed, and if not, an adequate risk mitigation plan is in place. The management is made aware from a risk management perspective. From a control perspective, an independent controls team would need to be present or created or entrusted with to test samples or to test each where feasible, but at least a sample testing would be required to be put in place so that during analysis or audit we can demonstrate adequate controls in place with a very specific aim which can demonstrate their fairness and explainability. So there is a role for a risk manager, there is a role for a control team so that it protects the management from any negative remarks. The next case study is AI used for CV screening in recruitment, primarily around the employment sector, but not just limited to the employment sector. It is about the recruitment team in any organization using AI. In this context, a multinational corporation implements an AI system that screens CV and ranks job application. It uses natural language processing and historical hiring data. This will hit the EU Act on Annex 3, Section 4B, which specifically for AI for recruitment and selection. This is high risk, clearly marked because it impacts access to employment for an individual. So it is a high risk. The first and foremost requirement in this would be the system must be registered in EU AI database and comply with risk management and monitoring protocol. Any relevant risk management and monitoring protocol. From a requirement perspective, as we mentioned, documentation is the key. How did AI come to a conclusion about a CV which was selected or which were rejected? What was the rationale? What are the parameters? Which was the tipping point for selection or rejection? The logic they have used. In addition, a documentation would be required on the training data that was used by this AI to build its knowledge base that it used for doing the final analysis when the actual resumes came into the system. The documentation also will need to ensure that the controls that is put in place, which can clearly demonstrate how biases are managed, if any, instruction manuals, audit trails, end to end would need to be in place. And one of the important and the final one is human review of recommendation from AI. It's not AI just recommended and there was no other filtering, it just went through. A human intervention is required for the final decision. Again, few teams would have to play a very important role. One is the team which manages the tool, technical documentation, process documentation, decision making logics. All of these need to be put in place even before the system is in production. Don't put a product system into production without these, because the moment it becomes active and it starts performing, even a single instances can cause issues to the organization. So insisting on this documentation before going live is primary. Second, the risk management team, the controls team, the management who owns this specific system needs to have a periodic review, sample testing on the actual data to see whether any biases were done, were there any instances. This is to ensure that enough due diligences are in place. If it can be automated, fantastic. If not, minimum quarterly review of this would be required, or a sample percentage would need to be taken to review the rejection and those which were accepted. Both the cases would be required in a safe number from the overall CVs that has come for processing. The next case is AI for predictive policing. It is part of the law enforcement sector. But do note, when we say policing, one is, of course, the law enforcement, which is outside our presence, but we might use certain AI for infrastructure which is private. There might be certain criteria that we need to also be mindful of. In this context, a city police department uses AI to forecast potential criminal activities in specific neighborhood based on historical crime data and behavior pattern. In this, from an EU AI Act perspective, this hits the Annex 3 Section 6B, AI used in law enforcement for predicting criminal offenses. This is high risk due to potential violation of civil liberties and profiling. The outcome is its use is only permitted if compliant with fundamental rights and legal safeguard under both the AI Act and the Charter of Fundamental Rights. So it can only be permitted if it is compliant with the fundamental rights. The requirement here is justification of purpose. When we say justification, it's not just we give justification, it has to be agreed by the right authority, by the courts, or a body which has the authority been provided. Data would be required. No final decision can be taken without a human in the loop. And audit or an assessment, either sampling or on a fixed cycle, needs to be done so as to ensure there are no biases. The next case is AI in medical diagnosis support, healthcare sector. In this, a medical tech firm develops an AI system that assists doctor in diagnosing early stage cancer by analyzing radiology images. This hits the Annexure 3 Section 1, wherein AI in medical devices under the existing EU medical device regulation. So that's where it will hit. It is high risk due to the direct impact on health and safety. So whenever AI touches health and safety, it is nothing but a high risk AI system. It will be considered that way. It requires conformity marking, clinical testing and validation, risk management and traceability. Basically, how did AI come to that conclusion? All the logics would need to be there. It can take a decision, but the final decision has to be taken by a human. It is just not an AI saying there is certain diagnosis. A human, a doctor would be required in the final say with a very clear trail, an audit trail, how this was arrived. The outcome expected is rigorous life cycle documentation and quality assurances are required. Such systems are allowed only if certified by a notified body. So basically, these type of systems just can't put into play, into production. It requires to be certified and notified by a authorized body. The last case study for this discussion is AI used in educational assessment. So hence coming from the education sector, the context is a national education board implements an AI system to grade students' essay for university's entrance exam. It uses NLP and learning models to assess writing quality. Now, this hits the education aspect, which is Annexure 3, Section 4A. AI systems used to determine access to education or assess learning outcome. A human is directly impacted by the outcome of this AI system. So, hence, it's a high risk due to the impact on education rights and fairness to that individual. No escape route. The moment the description of AI touches an education assessment or education rights, like the earlier examples of something touching a kid, or children, that becomes higher in the system, unacceptable category. In this case, it's education, so it becomes high risk. Similar to the earlier case studies, transparency is key. How AI took a decision about something being good, bad, or ugly? How does it ensure that biases are not in play? Can the logic be explained to a student? What are the mechanisms the AI system has to appeal against a particular grade? Is there a process? Could be an independent process with respect to this usage of the AI tool. The expected outcome is if the system fails to comply with non discriminatory and explainability requirement, it may be suspended or disqualified. So basically, complying with non discrimination and explainability requirement is the key here. If it is able to maintain it, then it continues with all the other requirements that's already put up. But the moment it fails in this too, the system cannot go through. But do note, this is not just when the AI system is put into play, it is before the play, and as the system is in production, you will need to demonstrate that it still remains non discriminatory and explainability can be done, which means the respective audit team, risk team, controls team need to come out with a plan as to how they are going to achieve this as part of their governance. Let's now try to summarize the case studies against the risk. So, the first one was about AI in credit scoring. It is from the BFSI sector. This was related to financial discrimination and privacy. Second was CV screening. The key risk was bias in hiring or unfair job access. Next was predictive policy. This is about the risk is around profiling and human rights infringement. Next was medical diagnostics. The risk was around patient safety and diagnosis errors. The last case was around student assessment. The key risk around this was fairness and educational access. As a snapshot, we have taken four sectors. Do note this all comes under Annexure 3, spread across section 4, 1, 4, 6, 5. So basically, when we look at these examples, we understand the breadth this act can be applied or is applied. From your perspective, you have to take these examples as a view, go back onto your drawing table, look at your area of business, bring out the assets, AI assets that you have currently. Try to map these assets around the risk. If it matches with any one of these, or you can go for a broader brush, you can look at the AI Act itself and see which part of the risk your AI asset fits into. The moment you know where it fits into, which risk it gets mapped easily, you also have a view about the annexure and the section and the subsection. So that's a task from these samples. Hope this helps you. Primarily, this will boil down from top to bottom, and the risk management team, the audit governance team, the controls team, general management, regulate management, which manages the regulators on your behalf. So, all of them need to come together to do this first hand mapping. This is something which will be done if you are involved or triggered a pre audit of your estate. Now, let us look at the definitions and the technical aspect of it. With the case studies behind you, you can now try to correlate what is the definition and how it looks like on the ground. This helps with a better perspective when you're managing the show. High risk AI systems are those that have significant implications for health, safety, or fundamental rights. These systems are subjected to stringent requirements, which includes implementing measures to identify and mitigate risk associated with the AI system, ensuring the quality and integrity of dataset used in training the AI models, maintaining comprehensive documentation to demonstrate compliance with the Act, providing clear information to users about the system's capabilities and limitations, designing systems to allow for effective human intervention and oversight, ensuring AI systems are resilient and perform reliable under various conditions. Now, if you just pause and look back on what was just mentioned, from a risk management perspective, you should be able to measure, to identify and mitigate. Measure, to identify and mitigate. How do you identify and how do you mitigate? This should be very clear when looking at your system which falls under this high risk category. The data sheet that is used for training, you need to ensure the quality and the integrity. You have to ensure there are no biases. Do your best, document it to demonstrate that this was factored in. The data sheet used for training have been cleaned up for any biases. Documentation, and I think this is something which I mentioned few times already in this series. Documentation is the key because that is what will be reviewed during an issue or during an audit, specifically how you are complying to the act. Then, very interesting, what is the capabilities of this tool that you are using and system that you are using with their limitation. Just ensure that your capabilities are articulated well, the limitations are documented, which could be a big piece because it's not that it is a silver bullet solving all your problems. So limitations would be a big area, that where the scope ends for that AI tool. It should be clearly articulated. You should also have the process and the documentation in place to demonstrate how human intervention and oversight is designed into the system or the process managing it. And the last is how the system would work in different conditions, primarily around resiliency. Can the system break? In what condition? And what are your design or plan when it breaks? From a system perspective, a high risk system can fall into different categories. A system used for risk management, a system can be used for data governance, a system can be used for maintaining documentation and record keeping. A high risk system can be from something which provides informations to stakeholders. A high risk system can also come from places where critical infrastructures are managed, like electricity and water supply. A high risk AI system can or we have seen use in educational and vocational training, influence the education and professional advancement, can also come from or be used as for employment. We have taken examples of this. A high risk AI system can also be used for essential services, law enforcement, border control, and judicial decision making. Now, this phase is in its early stages, few of them, but highly debatable at this point of time on the pros and the cons. Having said that, it means any AI system which is used for decision making from a judicial perspective, it will be classified as high risk. There are exceptions under certain conditions. Example, if an AI system performs a very narrow procedural task, that means as part of an overall process, AI has picked up a small section in that process, providing a small task, maybe adding a little small value to the overall process. In such cases, it might not be marked as high risk, but it has to be taken case by case. It could also be that the AI system improves the result of a previously completed human task. That is, there was a human intervention in the overall process. There was an output which has been done or taken. That output forms the input to an AI system, and AI system improves the accuracy maybe or the quality of it. Then it is likely that it won't be considered as a high risk AI system, or it is used to detect decision making pattern or deviation from prior decision making pattern and is not meant to replace or influence the previously completed human assessment, which means a decision has been taken by a process completely by human, and AI is used to maybe counter check it, recheck, or double check to ensure or to validate what decisions were taken were in line with separate. It's like a maker and a checker. So the maker and the checker were humans, but then we wanted to double check it and we use a AI to do that. But in this case, the AI is not the final say, it is there to validate it. If it's all in the same line, the human takes the decision. If it is not in line, then the, the process flows back to the human to revisit and review it. So the AI helps the human for ensuring that all are in place, all the checks are in place, and the results are in line. A system can also be taken off from the high risk list if it is performing a preparatory task to an assessment relevant for the purpose of use case listed in Next 3. It means the actual work is done by a human, but then before the work starts, we use AI to do a pre check or sanity check. In such cases, that system would not necessarily be considered as a high risk system because the major influence around the whole process is with the human. Let's now look at a critical aspect of the EU Act is the European Commission. The European Commission plays a central role in the governance, implementation, and enforcement of the EU AI Act, which came into force in August 2024. The key responsibilities were as below. The Commission operates through the AI Office, its internal body responsible for overseeing the application of the AI Act. The AI Office manages the implementation, monitoring, and supervision of AI systems, particularly general purpose AI models like ChatGPT. It issues standardization requests to European Standardization Organization, translating legal obligation into technical specifications. Additionally, the Commission adopts secondary legislation and provides guidelines to clarify compliance requirements, especially for high risk AI system. The Commission has the authority to classify an AI system as high risk or determine if general purpose AI model pose any systematic risk. This classification influences the level of regulatory scrutiny and safety requirements this system must meet. Recognizing the challenges faced by smaller innovators, the Commission is actively seeking feedback to reduce the regulatory burden of the AI Act on startups. This initiative aims to facilitate easier compliance, particularly for smaller innovators. Through initiatives like the AI Pact, the Commission encourages AI providers and deployers to voluntarily comply with key obligations of the AI Act ahead of time, fostering a collaborative approach to regulation. In summary, the European Commission, primarily through the AI Office, is pivotal in shaping the EU's AI landscape by enforcing regulations, providing guidance, and supporting innovation to ensure the responsible development and deployment of AI technology across the Union. Do note in our earlier conversation on high risk AI system, chapter 3, we had mentioned about certain places where the systems might be not applicable as high risk. This applicability, the decision for it comes from the commission. The commission can add or modify the conditions through delegated acts if there is a concrete evidence that an AI system falling under Annexure 3 does not pose a significant risk to the health, safety, and fundamental rights. They can also delete any of the conditions if there is concrete evidence that this is needed to protect people. AI systems are always considered high risk if it profiles individuals, that is, automated processing of personal data to assess various aspects of personal life, such as work performance, economic situations, health, preference, interest, reliability, behavior, location, or movement. Providers that believe their AI system, which falls under Annex 3, is not high risk, must document such an assessment before placing it on the market or putting it into service. 18 months after entry into force, the Commission will provide guidance on determining if an AI system is high risk, with list of practical examples of high risk and non high risk use cases. So now we are concluding this part 3 of the EU AI Act. So we have covered introduction, background and legislative journey, triggers for creating EU AI Act, case studies on the triggers, key objectives and features of the AI Act, scope and applicability, impact and significance. We have covered risk-based classification of AI systems, definition of unacceptable risk. We understood the prohibited AI system, what it means at chapter 2, article 5. We are now aware of its applicability from 2nd February 2025. We have looked at case studies related to prohibited AI systems in part 2. In part 3, we covered high risk AI systems, chapter 3, article 6. We have looked at case studies that illustrate high risk AI systems. We have also looked at risk based classifications of AI systems. We have seen the role of European Commission. So at this point of time, we have covered 3 parts. We will have few more to go. So I would request all of the subject matter expert management staff to think through the learning that we have done till now. I would suggest, as advised earlier, do a pre-assessment of your assets, scope it between what's in Europe, what's outside Europe, what is the risk category, what are the key objectives of those applications. Try to categorize what is as high risk, what is prohibited. Look at the reference on chapter 2, chapter 3, article 5, article 6. This should help you to tabulate your assets and services in the appropriate category. Once that categorization is done, is where your next actions will start. So this should help summarize and prepare yourself to meet any query, investigation, or concerns raised by EU in future. The best wishes. Thank you. With this, we end the part 3 of this series. We'll see you in part 4. Take care. Have a good day.